Right, well, I've been asked to say something about the trade union bill, which was introduced last July by the Tories and is currently going through the normal process in the Houses of Parliament. At present, today on the 19th of April, it's in the House of Lords, going through the committee stage, and it'll have to go back to the Commons to be finished, and it'll probably get the royal assent in June or July, or possibly in October when Parliament resumes. It will then have a commencement order will start, or most of the provisions will start a month or so after that. So we can expect the bulk into effect by the end of the year. The bill was introduced as a piece of opportunity, as a piece of opportunism by the Tories. They didn't expect to win the election last May, and they had no particular plan to reform trade union law. But when they got into office, obviously foreseeing the huge rifts that there would be in the Conservative Party, in particular over the EU referendum, they decided they wanted to do something that would unify the Conservative Party, and what better than to kick the trade unions. So many of the ideas had been published in a paper in 2010 and find form in the trade union bill. But we ought to be absolutely clear, this bill is not addressing any particular problem. And it's ironic, really, that the day before the publication of the bill, the Office for National Statistics published its annual review of days lost due to industrial action, and the figures produced show that really there's been no significant change for the last 10 years. It's about 730, 750,000 days lost per year, and it's been like that for a long time. In fact, in that publication, the Office for National Statistics said this. They said there's been a significant decline in the number of strikes since 1995 compared with the previous years. Though volatile, the number of working days lost has remained broadly the same over this period. The strike rate in the last 10 years is generally lower than in previous decades. So there is no problem in Britain today over strikes. So one obviously asks the question, well, what is this for, apart from trying to unify the Conservative Party? And of course the rationale and the real reason why the Conservatives hate the trade unions is because they are neoliberals, and neoliberals regard trade unions and collective bargaining as impediments to the operation of a free labour market, where wages, terms and conditions should be determined by the lowest possible for which people are prepared to work above subsistence. And that's really what this is all about. It's a very serious piece of legislation for the trade unions. However, it's been described as an existential moment, in other words, that trade unions are at risk of going out of existence altogether. I don't think that's completely true across the entire trade union movement, but I certainly think that it is very, very serious, and some unions are at really grave risk of being reduced to a rump. Now, the bill has got 7 separate aspects, which in the few minutes allowed to me, I'll try and touch on very briefly. The first is in relation to industrial action, the imposition of thresholds and turnouts. As everybody knows, before a trade union can take lawful industrial action in this country, it has to have a ballot preceded by a notice of ballot, and subsequently a notice of industrial action, but it has to have a ballot in which the majority of members who are likely to take the industrial action have voted in favour of industrial action. Now, there is a further condition which this bill will impose, namely that there has to be a turnout of at least 50% of the balloting constituency in order to render the ballot valid. So it's got to be a majority, and there must be at least 50% in favour. So this gives rise to obvious anomalies. For example, if you've got a workplace of 1,000 people, 499 of them vote in favour of industrial action and none against, that will be an invalid ballot. Whereas if 499 of them vote in favour of industrial action and one votes against, you then achieved your 50% turnout, and that will be a valid ballot. In addition to that, in so-called important public services, health, education up to the age of 17, transport and various other things, fire service, there will be a requirement that at least 40% of the balloting constituency voted in favour of industrial action. This is a real irony for a government that was elected by about 1/3 of those who voted and only 24.6% of the entire electorate. So if these thresholds and turnout requirements applied in parliamentary elections, we'd have no government. Anyway, those are major problems. They are certainly not in compliance with international treaty obligations which this country has ratified. They are incompatible, in my view, with Article 11 of the European Convention, which guarantees freedom of association and the right to be a member of a trade union. They're incompatible with ILO, International Labour Organization Convention 87, which also guarantees trade union autonomy, for the simple reason that trade unions have the right to determine the contents of their own constitution, provided what they're proposing to do is lawful, and these are obligations which overrule the trade union rule book. So that's the first proposition in relation to industrial action. There is, of course, a lot more to be said about that. There's various conditions, various requirements to go on the ballot paper and so on, but time does not permit. The second area is in relation to picketing, and this too is a serious impediment to trade unions, also in my view in breach of international obligations. This requires that every picket must have a picketing supervisor with an armband or something distinguishing him or her as the picket supervisor, with a letter authorising the picket from the trade union, and more dangerously, a requirement that the picketing supervisor gives their contact details to the police. Well, let's not talk about the distinguishing feature of armbands and badges and all the rest of it, which identifies the picketing supervisor as an active trade unionist, which will deter many. Let's just think about the implications of the picketing supervisor being required to give their contact details to the police. The bill imposes no restraint on the use to which the police put that information, neither is there any limit on the length of time that the police can hold that information. And since they know by definition where the person works and what their contact phone number is, it would be very easy for the police to obtain further information about that individual. This is the provision, by the way, that the Tory MP David Davis described as being more reminiscent of Franco's Spain than a modern democratic society. Well, I was involved in the litigation against the blacklist, which is currently ongoing in the High Court, and in the course of that litigation it was revealed that there had been a meeting not so very long ago between a senior police officer and the blacklisting organisation, the consulting association set up by many major construction companies. We don't, of course, know what was discussed at that meeting, but it doesn't take a lot of imagination to think why a senior police officer should be meeting with an organisation dedicated to blacklisting active trade unionists. And it seems to me that the effect of these requirements on pickets will be chilling indeed. Because you have to remember, of course, that most trade unionists that go on strike or stand on picket lines are not hardened militants that do it over and over again. They are ordinary working people who've probably never been on strike in their lives and almost certainly never stood on a picket line. Yet they will be required to identify themselves to the employer, to any member of the public who passes by, and to the police as somebody who is prepared to take on the role of picket supervisor. And of course, picketing is going to assume a particular significance after this bill, because the government is also proposing to remove the bar on employment agencies supplying strike breakers to fill in when workers are on strike. That means that trade unions will, and workers on strike, will seek to put pickets everywhere where strike breakers might try and enter the premises. So let's move from that to another really fundamental aspect of the bill, which is political funding. Since 1913, trade unions have been required to separate out the funds that they hold for political purposes with the funds that they hold for all other purposes. And since their funds almost exclusively derive from the subscriptions of members, members have to subscribe separately to the political fund. And from 1913 onwards, this was done by allowing members to opt out of the political contribution if they wished to do so, apart from a period after the general strike in 1926, when the Tories, to punish the unions, required union members to opt in, repealed by the Labour government after the Second World War. But now the Tories are proposing to revert to that, and the idea is that trade union members will have to opt in to payments into the political fund. There was a huge debate in the House of Lords in a couple of weeks ago about this, and an amendment was passed, one of three amendments passed, this one by 320 votes to 172, which would amend the bill by requiring only new members of trade unions to opt in, rather than all existing members to opt into the political fund. So we will have to see whether the government relents on this requirement or whether they will revert to the original plan. But this is very significant for trade unions. It's significant for the philosophical point of view that trade unions don't just have an industrial purpose, they have a political purpose as well. They are the bodies who promote legislation. It was trade unions who were the main driving force behind health and safety legislation in the 19th and 20th century. So not only do they have a political voice, they also, of course, as everybody knows, founded the Labour Party at the turn of the 20th century. And the Labour Party reckons that if the opt-in requirement applies to all trade union members, as the government proposed, this will cause them an annual loss of £6 to £7 million, which will obviously affect democracy in this country. Once again, it seems to me that these provisions are in breach of Article 11 and International Labour Organization Convention 87 for reasons that we haven't really got time to go into. Next provision is in relation to facility time. Facility time is the time off that employers give to trade union representatives in their employment in order to carry out trade union duties. Now here we're not talking about branch officials planning what the agenda of the next branch meeting is, or even drafting motions to go to the annual conference. What we're talking about is trade union duties such as serving as a safety representative or on a health and safety committee, or under Section 10 of the Employment Relations Act, representing members in grievance and disciplinary procedures. It's this facility time which is under attack by this bill, and the proposal is that public authorities will be required to publish the amount of time off that trade union officials are given and what the cost of it is to the employer. No requirement, by the way, to publish the value of the benefit of this time off for the employer. And the government's bill originally proposed that there would be reserve powers which would enable the employer to cap or limit the amount of facility time given. Now, of course, that would be a clear breach of Article 11 because it would interfere with collective agreement, because all or nearly all facility time is given pursuant to collective agreement between the union and the employer. Allied to facility time is check-off. Check-off is the arrangement by which a worker instructs his employer, his or her employer, to deduct his union contributions from his or her pay and remit it to the union. This is widespread, particularly in certain unions like Unison, and the union usually pays the employer on account of the administrative time that it takes and administrative resources it takes to make these deductions and pay them over to the union's bank account. The proposal in the bill is that check-off will no longer be lawful. So you can instruct your employer to deduct money for maintaining your child, or to pay to a cat's home, or for any other charitable reason, but the one thing you will not be able to do after this bill becomes law is to instruct your employer, even on payment of the expenses of doing so, to pay your union contributions, take your union contributions from your pay and pay it to the union. Once again, that's a breach of collective bargaining, because collective agreement rather, because all these check-off arrangements are by collective agreement. Okay, final issue in this bill is the certification officer. This is a state official who originally was to keep a record of unions which were certified as being proper trade unions and independent and so on, but since then has acquired the power to investigate and decide disputes between union members and their union. And hitherto, this jurisdiction has always been dependent on a member making a complaint to the CO, the certification officer. This bill proposes that the certification officer, for many parts of that jurisdiction, will be able to initiate complaints him or herself. That means that he will initiate the prosecution, he will sit in judgment on the prosecution, he will hear the defence of the trade union, and he will decide if the union is guilty or not, and if guilty, will impose what will now be a fine of up to £20,000. So that's a whistle-stop tour of the bill. Only a brief excursion through the points demonstrates what an outrageous insult to democracy it is. And the trade unions and all their sympathisers in the conference will obviously be determined to do what can be done to resist. Thanks for listening.